それではこれより総括のパネルディスカッションを開始いたします。ご登壇の皆様をご紹介いたします。まずパネリストの皆様です。日本から高部真紀子知財高裁所長、服部誠弁護士、韓国からキューホン・リー裁判長、サン・ウクハン弁護士、中国からワン・ヤンヤン裁判官、チー・シュエ・ウェイ弁護士、オーストラリアからジョン・ニコラス裁判官、サラ・マシソン弁護士、インドからプラティバ・シン裁判官、プラビン・アーナンド弁護士、そしてモデレーターは関根澄子知財高裁判事、そして古城晴美弁護士です。それではここからはモデレーターのお二方、どうぞよろしくお願いいたします。
Good afternoon, everyone. I'm Sumiko Sekine.
I am Harumi Kojo.
Okay, thank you for staying us for this panel discussion. We will be moderating this session. It is a rare opportunity for IP judges and lawyers from 5 countries to gather and share their insights. We hope you will enjoy this special occasion. So please look at the chart on the screen for the outcome of the mock trials. Interestingly, the outcome was split, and Japan and India found literal infringement. And for China, I thought you said you found literal infringement, but could you confirm your conclusion?
First of all, let's clarify that our judgment holds the accused infringed technical solution constitutes literary infringement. To strengthen the reasoning part of the judgment and to make the parties, especially the defendant, accepting our judgment, we take a writing method of the judgment. We assumed that defendant opinions, which the first memory means and the second memory means, is limited to the CD-ROM and RAM correctly, and the accused infringing technical solution also constitutes an equivalent infringement. We want to express the court's opinions about the MOCO case comprehensively. In the other aspect, all the legal effective judgment will be uploaded to the Chinese judicial judgment website and is open to the public. We wish that judgment about this MOCO case will be served as the guideline case of the similar dispute in the future. Of course, if it's a simple case or the judge in charge of the case is very busy, very simple and straightforward judgment will be rendered. So the conclusion is the literary infringement.
Okay, thank you. So Chinese court mentioned, explained about doctrine of equivalence, but it was just an explanation. So the conclusion was literal infringement. And on the other hand, Korea and Australia found no infringement. And Korea determined the doctrine of equivalence but did not apply the doctrine. And in Australia, doctrine of equivalence is not applicable. So this is the outcome. So we'd like to focus on differences in how each country construed the claim terms in the mock trial. And we'd like to discuss how each country considered the claim terms and the specification. And then, if time allows, approaches to the written document submitted in the prosecution history, but if we don't have time, I might omit this topic. And lastly, we'd like to discuss to what extent the plaintiff has to specify the features of accused product or method in order to make a comparison to the features of the patented invention. So now let us get started with the first topic. First, I want to ask Japan to Chief Justice Takabe. I have two questions. The first question is, does the court always consider the specification or only when the claim terms are ambiguous? And when the court refers to the specification, does the court limit the scope of the claim terms to the embodiment or not? Judge Takabe, please.
Thank you. Article 70 of the Japanese Patent Act stipulates that the technical scope of a patented invention shall be determined based on the statements in the scope of claims and in consideration of the statements in the specification. The court refers to the statements of the specification, including the cases where the claim terms are not ambiguous. In Japan, the court construes the claim terms in light of the technical significance of the patented invention based on the statements of the objective of the invention, the means to resolve the problems, and the effect of the invention in the specification. Furthermore, the scope of the claim terms should not be limited to configuration of preferred embodiment when there is no limitation in the claim. In 20th century Japan, a defendant was not allowed to assert patent invalidity defense in infringement lawsuit. However, in cases where the patented invention included publicly known prior art, it would be an injustice to conclude that the defendant's act, which satisfied all the elements of the invention, as an infringement. Therefore, the court used to limit the scope of the claims to the embodiment disclosed in the specification to draw a conclusion of non-infringement. The court no longer adopts such method of construction because it is now allowed to assert invalidity defense in infringement lawsuits under Article 104(3) of the Patent Act.
Okay, thank you. So in Japan, the court always refers to the specification, but the scope of invention is not limited to embodiments. So now we would like to know how you construed the first memory means and the second memory means in your mock trial. Could you explain?
In the mock case, the first memory means denotes a means in which facility data are prestored, and when one facility is designated, these out coordinate data corresponding to the designated facility. And the technical significance of the second memory means lies in its function for storing coordinate data read out from the first memory means as user-registered data according to the statements of the specification. Therefore, we concluded that the second memory means should be construed as a means for storing user-registered data distinct from facility data, and there is no reason to use separate media for the first memory means and the second memory means.
Okay, thank you. Let me confirm. In your mock trial, you referred to the paragraphs 0003 to 0007 and 0020, and which are the paragraphs stating conventional art and the objective of the invention and mode of operation of the invention and the effect of the invention to find the technical significance of the invention in this case. Is my understanding correct?
Yes, that's correct.
Okay, thank you. Thank you, Chief Judge. Now, I would like to ask Korea. My first question is the same to the one I asked to Japan. Does the court always consider statements of the specification or only when the claim terms are ambiguous? And when the court refers to the specification, does the court limit the scope of the claim terms to the embodiment? Judge Lee?
Yes. The Article 97 of the Korean Patent Act prescribes that the protection scope of patented invention shall be determined based on the description of a claim. As almost all countries have such rules, in my opinion. But if the technical constitution of the patented invention cannot be understood, or even if understood but the technical scope cannot be specified by the description alone, the invention may be supplemented by other descriptions of the specification. Even in such case, the extended interpretation of the claim is not allowed by other descriptions of the specification. In addition, if the technical scope is clear from the description of a claim alone, the description of the claim cannot be limitedly construed by the other descriptions of the specification. Thus, in principle, the protection scope of a patented invention should be defined by the description of a claim and cannot be limited or extended by the specification or the like.
Okay, thank you. So in Korea, the court refers to the specification only when the claim terms are ambiguous. So, and when it is clear, you don't refer to the specification. You just read the language of the claim terms.
Yeah.
So it's different from Japan. Is that correct?
Yeah,
Okay.
partially correct.
So it's interesting. It's very difficult, different from Japanese practice. Okay, then my next question is, could you explain how you defined the first memory means and the second memory means in your mock trial? And please mention which paragraphs you referred to, if you refer to the specification.
Yes, in this case, the description of the claim, first, the technical constitution and the scope of the claimed invention cannot be clearly defined, I think, as to how the first and second memory means are formed in a car navigation system. It's not clear. So in this regard, the specification, the description of the specification is needed to construe properly the claim. So, with reference to the description of this specification, 0015, which concerns the first and the second memory means, it can be known that in one embodiment of the invention, the first memory means is CD-ROM and the second memory means is RAM. Yeah. So we, the 0015, we refer to that paragraph, and 0015 paragraph, according to, based on the 0015 paragraph, we construe that claim.
Okay, so thank you. You mentioned that the first memory means or the second memory means are not limited to the configurations disclosed in the embodiment. So first memory means is not limited to CD-ROM, and second memory means is not limited to RAM. However, you concluded that those means encompass the means similar to the configurations disclosed in the embodiment. My question is, why do you interpret the term means as the means similar to the means disclosed in the embodiment?
Yeah. I think so. According to specification, the specification says, for example, the first memory means is the CD-ROM, and second memory means is the RAM, and it's just it's an example, I think, and it cannot, specification cannot limit the claim, the interpretation of claim, and the claim itself don't have its limitation, as you see. So we can interpret the claim referring the 0015. So we can, the first and second memory means are not limited to CD-ROMs and RAM only. It's the interpretation of the claim. And it means the claimed elements are considered to encompass any types of means that are similar to those disclosed in the specification or other versions thereof, which could have been practiced by a person of a POSITA in the view of a description of the specification at the time of filing the application. Yeah. So in result, the 0015 paragraph is the one example of interpretation, and we can we understand that paragraph cannot limit the claim's scope.
Yeah. So you don't you cannot limit the scope of claim, but still it's limited to something similar to the embodiment.
Yeah.
Okay. So let me ask from a different angle. In your judgment, you determined the doctrine of equivalence, and you mentioned that the essential technical idea of this invention is to configure the system at low cost and improve convenience by differentiating the memory where facility data are stored and the memory mean where user registered data are stored, which is written in the paragraph 0015. So how did you find this paragraph, the statement of this paragraph as an essential technical idea of this invention? Why is this part you find it essential?
Yeah, it's the specification obviously says that the gist of technical idea of this invention is the reducing cost and boosting convenience. That's the main purpose of this invention, I think. But this server and the method don't mention about such purpose, we think. So we compare the main idea of this invention and this server, and in result, I think the specification obviously says the main purpose of the invention.
Okay, so I understand that Korean court found the essential part of this invention as what is written in paragraph 15. And in comparison to Japan, Japan considered paragraphs 005, 007, or 020. So now I think we can find the difference here. Okay, thank you very much, Judge Lee. Now I would like to ask China. So the same question. Does the court always consider statements of the specification or only when the claim terms are ambiguous? Judge Wang?
According to the stimulate we have shown as in our slide, there are some provisions that the principle when we interpret the claims and determine the scope of the protection of the patent, we should determine it in accordance with the claim. But when the claim is ambiguous, we will consider the specification and drawings. But the Supreme have made some established cases and guideline cases and developed some judicial rules for the for the judicial practice. And we have another new interpretation, judicial interpretations said, when the People's Court make interpretation by applying this special fiction and joins relevant claims in the patent claims and patent exam files, where the language of the claims is special defined in the special fiction, such special fiction definition shall be accepted. So, in the judicial practice, if the claim is not ambiguous, the special fiction and join is also useful for the court to determine the scope, protection scope of the patent.
Okay, thank you. So, I understand that in China, you always consider the specification and claim as a whole because it is stipulated by the patent law and judicial interpretation by the People's Court.
Yes.
Okay, thank you. So the next question is, could you explain how you construed the first memory means and the second memory means in your mock trial? And please mention which paragraphs you referred to.
In the MOCO case, according to the text of the claims of the patent, there involved the data proceeding of two kinds of data, have different properties. The first memory means is configured to pre-store data of multiple service facility, including the display data, coordinated data, and so on. And the second memory means is configured to store user registration data, including the coordinated data of particular service facility designation by the user. According to the paragraph 005 and 0020 of the special fiction, the purpose and effect of the invention is to provide a control method for automobile navigation system so that the user, without knowing the exact location of the service facility, can use the label, the qualification to get the destination. So based on this purpose and effect, we think the ordinary technician in the field knows that the first memory means and the second memory means are provide two kinds of data and not to define the physical medium for storing the two kinds of data after reading the special fiction and drawings. And they will also know that the first memory means and the second memory means may be located in the same physical storage device or in different physical storage devices.
Okay, thank you very much. So you referred to the text of the claims and the paragraphs, mainly 0005 and 0020 of the specification, which are the statements of the objective of the invention and the effect of the invention. So, and you found that those memories are memories to store two kinds of data, and it could be in the same device or different devices. It doesn't matter.
Yes.
Okay. And so, and it is because of the adjudication rules in the judicial practice of the People's Court mentioned that when understanding of the claim is disputed, the purpose and effect of the invention described in the specification is considered. So that's, you applied this judicial practice to this case, and you concluded the case in the way you just explained. Is that correct?
Yes, I think so. It's correct. The reason are as following. The first one, as I have said, the purpose and efforts of the invention are as a part of the special fiction, so they should be taken into account. And number two, the purpose and effect of invention are the improvements made by the patent relative to the prior art. Mm-hmm. So the technical solution that fails to achieve the purpose of the effect of the invention shall not be included in the scope of the protect of the patent. And in that MOCO case, the purpose and the effect of invention, as I have said, to display the location of a surveillance facility through a simple operation when a user doesn't know the exact location of the surveillance facility. And the accused infringing technical solution also display the location of the surveillance facility through the same simple operation as the patent, and also achieve the purpose and the effect of the invention. So the storage device in the accused infringing technical solution is different from the storage device in the patent. But we think the storage device is irrelevant to the purpose of and the effect of the invention. So, and the claims in the MOCO case doesn't limit this into the claims. So we think the first memory means and the second memory means shall not be interpreted as the CD-ROM or the ROM in the embodiment.
Thank you. And they can be in the different devices.
Yes.
Okay, thank you very much. Thank you, Judge Wen. Now, I would like to ask India now. Justice Sin, does the court in India always consider statements of the specification, or only when the claim terms are ambiguous? Can you answer?
Yes. First of all, I wanted to know one thing. Is the draft judgment of all the countries going to be uploaded?
Yes.
Okay.
Yes.
So in that case, then I can refer to the paragraphs. Okay. So the two things that I would like to say is, yes, the claims have to be read strictly. However, the purpose of the invention has to be, first of all, ascertained. The two judgments which govern how a patent specification has to be read, I would like to read the two sentences as to what is the principle that Indian courts apply in patent specifications. The Supreme Court said that first, to read the specification, description of the invention, in order that the mind can be prepared for what it is, that the invention is to be claimed, for the patentee cannot claim more than what he desires to patent. So, when we read the patent specification, we obviously understand the background and the purpose of the invention from the text of the specification and interpret the claims accordingly. And the second principle would be that the specification has to be construed as a whole. It has to be construed impartially, and the court is generally slow to construe it against the patentee. So therefore, if there are two interpretations that are possible for a patent specification and the claims, the court would lean towards the patentee and the rights of the patentee. So these are the two basic principles that we follow in patent infringement suits.
Okay, thank you very much. So in India, you read the statements of the specification and the claim as a whole, according to those judgments.
Correct.
Okay, thank you. And I want to ask another question. You mentioned purposive construction in your mock trial. Could you explain what purposive construction is?
I think this audience has heard enough since morning about purposive construction. Obviously, purposive construction is a principle which we've borrowed from the British courts, just like other common law systems which are there. Purposive construction is a very simple construction by which the purpose of the invention has to be construed properly in order to, understand what the inventor is trying to say and what is the problem that the inventor is trying to achieve. So, though there's purposive construction, this principle has itself been kind of modified from time to time. You could call it the problem solution approach or the teaching suggestion motivation. That's the TSM test in the US. So irrespective of whichever test or principle that you may adopt, the intention of the court is to always assess what is the purpose behind the invention and what is the manner in which the claim is to be construed so that the purpose can be achieved properly.
Okay, thank you. Could you explain, in this case, how you construe the first memory means and the second memory means in the mock trial? and which paragraphs you referred to, and also how you applied the purposive construction you just explained in this case.
See, the way I look at it, this is a navigation system which is meant to make it very convenient to the user. The user need not remember the latitude, the longitude, or other important features. If he types in sushi restaurant under colony, there should be a result which is thrown up, right? So for that, the data has to be located in the two memory means. The manner in which the primary and the secondary memory means communicate with each other in order to be able to throw up the data for the navigation system is important. It's not the first and the second memory means which is the crux of this invention. The crux of this invention is how is the user going to be having more convenience while he is driving. So where he is storing the search, the keyword is not important. What is important is what is the search result that is to be thrown up. How is the search result to be thrown up? By communication between the primary and the secondary means. So the location of those means, it could be, for all that you know, in one hard drive, 2 chips. It could be anywhere. It could be a CD-ROM, it could be a remote server, it could be a particular CPU where there could be two chips which are communicating with each other. So the location, the geographical, physical location of the means is absolutely not relevant to this invention. What is relevant is what is the result that is thrown up for the consumer, that is the driver, and that is clear from paragraph 15 of the description that you've given. If you see paragraph 14 and 15, it says how the person is supposed to understand this invention and what is the convenience for the consumer. So that's the most important purpose of this invention. We have to interpret the invention for the purpose which it is seeking to achieve.
I see. So you read the specification and you found the purpose as to achieve convenience for the user, yes, as the purpose, and you construed the first memory means and the second memory means.
If you see page, for example, paragraph 13, it says that the CD-ROM recognizes the present location of the vehicle. So the important thing is all the two memory means are talking to each other.
Mm-hmm.
That's the important part.
Okay. So the location doesn't matter, yes, as long as they can communicate with
Absolutely.
each other.
Absolutely.
Okay, thank you. So when you construe the terms specification purposively, does it generally lead to broad construction and expand the construction, or could it be narrowed sometimes? How does it work?
I would not say that the court doesn't have the power to either narrow the construction or make it broad. However, as I said in the judgment, if you read location into the claims, the claims would read differently. It would read as control method for car navigation system installed in the car. The words installed in the car are not there in the claims. Mm-hmm. If they're not there in the claims, the court can't read those 3 words into the claims because of one embodiment which is stated in the specification. So the claims cannot be either broadened or narrowed, mm-hmm, but you cannot add language into the claims which is not there.
Okay, thank you very much. Thank you, Justice Sin. Okay, now finally I would like to ask Australia. In Australia, I understand that the court refers to the specification only when the claim terms are ambiguous. And could you explain why is it so?
Well, I think the first thing to note is that unlike the position that we've heard described in, say, Japan and China, we do not have built into our patent statute a particular direction as to how the claims are to be construed. So the way claim construction has developed in Australia is through case law, and we have now got some very well established principles that are very consistently applied. And the starting point is that if the claim is clear and unambiguous, then it is not permissible to either narrow it or expand it by reference to other parts of the specification. And you've asked why that's so. Well, I think the rationale is that it's a very important act that the patentee is undertaking when they are choosing the words of their claim. By choosing the words of their claim, they are defining their monopoly. And so therefore, maybe Justice Nicholas can answer this better than I can, but I think the court tends to make the assumption that the patentee has carefully chosen the words of the claim, and unless there is a good reason to go outside the words of the claim, that's what should guide the court. And it may be that sometimes the terms in a claim might be unclear, or there could be several different meanings which could be given to the claim, and indeed there might be conflicting expert evidence as to what those meanings are. And in that case, then the court would have recourse to the body of the specification to help resolve a meaning. But in the situation where the words could be given an ordinary meaning, and it's clear what that meaning would be, then the court would not need to go to the specification.
Okay, thank you. Also, Australia also mentioned purposive construction. Could you explain about the doctrine of purposive construction? Justice Glass?
Yes, I think purposive construction is something that can have a number of different meanings. When we use purposive construction in Australia, in one sense, what we're referring to is the obligation, when construing the patent, to read it as a whole and read it as it would be read through the eyes of the skilled addressee. That's purposive construction in a very general sense. Of course, in a narrower sense, the focus is on what's the purpose of this invention, what's its objectives, and to what extent does that influence how one construes the claim. But in Australia, we are very cautious about resorting to purposive construction for the purpose of broadening claims when there's language that one would usually assume has been deliberately adopted for the purpose of narrowing the claim. Bearing in mind that often a patentee, for good reasons, and it's often said for reasons known only to itself, will claim less than what it has disclosed in the specification. Sometimes it may claim more broadly, and in this case we know it has claimed more broadly in the sense that it is described in the body of the specification two specific types of memory means, but in the claim it's used much broader terminology. But the words first and second, and we're probably moving on to another question, are quite specific, and they are really picking up language that is apt to describe a particular configuration in the embodiment described in the body of the specification.
Thank you. So I think in India, Justice Singh mentioned that when you apply the purposive construction, they read the purpose or the effect and find the technical significance of the invention. But Australia seems to be more sticking on to the language of the claim itself. And you said you're cautious about reading the specification too purposively. Am I understanding correct?
Yeah, I think that is correct. If a claim is expressed in language which to the skilled addressee will appear reasonably clear, and in most cases if it appears reasonably clear to the skilled addressee, it will also appear reasonably clear to the judge. It won't be necessary to be resorting to purposive construction, however one describes it. So in this case, I concluded, although while one could argue about whether or not first and second memory means were two distinct things, integers in this combination, I thought on balance that it would be construed as requiring something like what one sees described in the preferred embodiment, accepting, of course, that there are different types of memory means that could be used in place of a CD-ROM or RAM.
Mm-hmm. So you're saying you didn't limit the first memory means the CD-ROM or second memory means the RAM, but you found that those means have to be separate and stored in distinct media or device.
Yes. And the reason for doing that is the claim doesn't refer to performing these functions using one or more than one memory means. It seems to me to be clearly contemplating that there will be two different memory means working in combination. And that would mean that as we construe the claim, you have to be able to point to a first memory means and also a second memory means in the way one sees in the embodiment described in the specification.
Okay, thank you very much. So the outcome was different, and as you can see, all the countries construed the claims differently, and especially it was very interesting to see that Japan, China, and India referred to the objectives and the effect of the invention. And on the other hand, Korea and Australia did not look into those paragraphs, and rather you look to the embodiment which showed separate media for two different means. Thank you very much. Now I would like to move to the next topic, and as I said, I will just summarize the outcome of each country by myself. And as you can see on the chart on the screen, in Australia, it is not permissible to consider the statements made in the prosecution procedure for the claim construction in infringement lawsuits. And in the mock trial, Justice Nicholas excluded the written opinion submitted in the prosecution procedure from evidence. And in the other four countries, the doctrine of prosecution history estoppel may be applied. But, however, none of the countries applied the doctrine in this case. So therefore, no country considered the written opinion in this mock trial. Now, I want to finish this topic now, and I would like to hand over to Ms. Kojo for the next topic.
Okay. Well, let us discuss the last topic. In the mock case, the features of the method per se was not disputed. However, in reality, it is often difficult for the plaintiff to specify the accused product or method. So I would like to ask some questions about how to specify the accused product or method at the time of filing a complaint. More specifically, my questions include the following. First, at the time of filing a complaint, to what extent does the plaintiff need to describe the feature of the accused product or method? Do the feature of the accused product or method need to be described very concretely or just at a high level? Also, is it sufficient for the plaintiff to point out that a certain product or method may be infringing the patent? Second question is, why, when the plaintiff needs to describe the features of the accused product or method, but is unable to get sufficient information, what can the plaintiff do? Third, how can a plaintiff gather information of the accused product or process before filing a complaint or at a very early stage of the lawsuit? And what are the measures taken if under this situation? And maybe it's better to first ask Japan this question.
Okay, thank you very much. In Japan, we don't have a system similar to discovery in the United States. Therefore, in principle, patentees need to collect evidence to prove infringement themselves. Under Japanese laws, there are some systems to collect evidence, such as the evidence preservation procedure and bar association inquiry system. However, practically speaking, in many cases, using these systems doesn't work well. The patentee bears the burden of proof as to the fact of infringement. At the time of filing a patent infringement lawsuit, a plaintiff is required to specify the features of the alleged infringing products or methods to be compared with the patented invention element by element. So, plaintiffs' attorneys face difficulties in specifying them when obtaining the product on the market is impossible, or when the production process is performed in secret in the defendant's plants. In cases where we cannot specify them, we sometimes choose not to file a lawsuit. On the other hand, even though we cannot actually confirm them, we sometimes decide to file a lawsuit after discussion with the client and conclude that the patent is possibly being infringed, taking into consideration indirect evidence or reasonable assumptions. In the procedure after filing the lawsuit, the defendant sometimes discloses the features of the alleged infringing products or methods based on Article 104-2 of the Japanese Patent Act. According to the article, the defendant shall specify them in order to deny the plaintiff's assertion. However, the proviso of this article stipulates that this shall not apply where there exists reasonable grounds. Therefore, in many cases, the defendant does not disclose such things, claiming that they fall within the company's trade secrets, and so there exist reasonable grounds. As plaintiff's attorneys, we sometimes conduct additional experiments in order to prove infringement scientifically. Or we sometimes point out in briefs that the defendant's counter-argument regarding the features of the alleged infringed products or methods is quite unreasonable. Further, we sometimes request the court issue an order to the defendant to produce documents based on Article 105 of the Japanese Patent Act, hoping that the judge requests the defendant disclose the relevant information voluntarily. If things go well, the defendant discloses the relevant information, sometimes after reaching a non-disclosure agreement between the parties. Thank you very much.
Thank you very much. For the convenience of Japanese audience, I would like to add some comments in Japanese. 服部先生は、日本の訴訟では訴えを提起するときにかなり詳細に 被告製品あるいは方法を、特定する必要があるということを最初におっしゃってました。でしかし実際には、それをやるのにかなり困難がある。で日本には、アメリカのディスカバリーのような制度がないので、原告としては証拠を集めるのにかなり苦労することがあると。で、そういう事情があるので、依頼者との相談であまり十分な証拠が得られないなと思った時には訴訟を断念することすらあるというお話がまず問題点として指摘されていました。それから、この困難性を回避する方策として、文書の提出命令であるとか、あるいは具体的対応の提示義務ですか、そのような制度があるけれども、被告の方でこれは営業秘密だというようなことで争われて、実際には開示しないこともある。でそういうことで、いろいろな困難がありますというお話を今されていました。This is a brief summary of Mr. Hattori's statement. So then, I would like to ask Korea about the situation in Korea. And in Korea, an accused product method should be specified fully in the complaint so as to be compared with a patented invention. So my question is, what happens if the defendant contends that the features of the product methods are not fully specified, and if there is a substantial difficulty for the plaintiff to describe the features of the alleged infringing product or method? And also, please explain what measures are taken if it is difficult for the plaintiff to specify the features. My questions are very broad, so you may have some difficulty answering the questions, but maybe you are very familiar with the Japanese situation, so in contrast to Japanese situation, what kind of measures are taken in Korean lawsuit?
この校長先生のちょっと要約をやらなくてもいいということで、ちょっとこの日本語で話をさせてください。このちょっと日本と、実はこの質問は私いろいろな企業を代理しているところ、日本の企業を含めもう常に出ているクエスチョンです。例えばですけれども、この三世電子とかに半導体装置を納品している会社がちょっと競合会社特許侵害品が納品されているようですけれども、どうしたらいいんですかとか、同じことで LG 化学にも部品とか素材を納品している会社でもやっぱり疑いはあるものの確証がない場合どうしたらいいんですかという質問で、結構私も悩んでいるところですけれども、まず訴状の段階では日本のプラクティスとちょっと異なって、より簡単なこの訴状でも基本的にはいいです。この理論的には裁判所の訴状を逆化する権限があるんですけれども、実務的にあまり活用されてないですので、訴状の段階では例えばこの被告の製品を原告のクレームに直結するものというぐらいの特定でも構わないと。もちろんこの訴状の段階でいろいろ方法があってこの活用する方法があったらいいんですけれども、証拠保全も日本と同じく定相前の証拠保全もできるものの、実際的に三世電子とか現代自動車に証拠保全に行くということはあまり実務的に難しいですから、それから定相前の証拠保全はそんなには活用されてないところですから、私はこの個人的には戦略としては何とかの疑いはあるんですから、このちょっと企業がこれはちょっと侵害品がこの納品されているようですという疑いの根拠をちょっとリストアップしてくださいと聞いたら、なんとか噂とかちょっと行ってみたこの人がいるとか、 そのようなちょっとリストアップができたら、それをどのように訴訟で活用するか、ちょっと、考えますけれども、法律的には、まずは、つい最近、韓国では、この被告の実施対応の提示の義務、日本がこの規定があるんですけれども、それをちょっと超えて、実施だ、このどのような実施をしているかを被告側にこの提示してくださいという義務だけじゃなくて、この、効率的な理由がなしで、このような提示をしないと、原告はちょっとリーズナブルな説明がつけられるんですけれども、被告はこれを拒否するということでしたら、原告の主張を真実に認めるという規定が今設けられました。まだちょっとケースはないんですけれども、この今年の7月からですから、でもそれがどのように活用するかでいろいろちょっと目に、ちょっと私も注目を持っていますけれども、同じく、文書提出命令、それがこの資料提出命令に改正されてるんですけれども、その場合も、例えばこのような損害賠償の算定とか、被告の実施のこのいろいろな形について、この資料提出命令をしたら、韓国では基本的にこの営業秘密だということで拒否ができない。裁判官がこれは必要だと、これがなければ原告側は負けますので、リーズナブルなちょっと根拠はあるんですから提出してくださいと言ったら、営業秘密だということは拒否ができない今条文が設けられて、その時は提出させながら秘密保持命令を出して、アトニーアイゾーンにこの、原告の会社まではちょっと渡せずに、弁護士だけにちょっと限られて公開ができるような、これが何回も活用されているところもありますので、結論としては、この私はやっぱり原告のこの立証責任が果たせなかったんですから、負けた経験はないです、実は。ないですので、なんとか効率的な理由があったら、被告が何をやっているかまでは立証できるんじゃないかと私は信じていますし、裁判官、最近、リー裁判長のような結構積極的な裁判長が結構出てますので、負けるんだと言っても、今日のようにちょっとこのクレーム会社とかそのようなことで負けることですので、やっぱり立証ができなかった、被告が何をやっているか、原告は立証できなかったんですから、負けますということはあんまり韓国ではないと思います。ちょっと話長くなりましたけど、はい、すみません。
Thank you very much. ありがとうございました。じゃあ、ちょっと追加で日本語で質問させていただきます。今のお話ですと、韓国の場合は訴訟の最初の段階では、かなり大雑把にこれというような程度で、ほとんどクレームの文言をなぞったような、製品の特定というか、なんていうんですか、説明をつければいいと。でその後で、もうちょっと争点との関係で必要になってくれば立証の方法を考えると、そのような扱いになっていると理解してよろしいですか。
そうですね、そうですね。訴状の段階ですごく大雑把な内容だと言って、訴状の段階でそれが却下されたりすることじゃなくて、はい、結局準備で手付けとかでどのように立証するんですかと、証人を読んだり、なんとか営業秘密の書類みたいですけれども、インカメラで裁判所だけにちょっと見せたり、いろいろな方法が講じられると思います。
それから今、被告の方で原告がある程度のことを言ったらば、自分の製品なり方法はこうだということを言わなくてはいけなくて、でそれを言えと裁判所に言われたにもかかわらず言わないと、それは制裁があるというふうに理解してよろしいですか。
そうですね、この原告がこのようなリーズナブルがこの疑いがあるんですからといって、裁判官がそれはちょっと納得できれば、被告にこの自分の方法とかものをちょっと開示してくださいという命令を出します。その命令に応じないと、原告の主張通りをちょっと認めて裁判の根拠にさせることができるような条文が今設けられます。
ありがとうございました。 So then I will next ask China. Please explain to what extent the plaintiff has to specify the features of the accused product or method at the commencement of a lawsuit in China. Maybe at the commencement is not a requirement for the Chinese lawsuit, but I think that there may be similar problems in the Chinese litigation. So, Mr. Wei, could you please answer these questions? ウェイ先生、よろしいでしょうか。
はい、よろしいですか。質問が3つありますけれども、1、2、3と、中国の訴訟の実務については、もしもよろしければ、3番目からお話を始めたいと思いますが、よろしいでしょうか。
はい、お願いします。
例えば、お客さんから連絡があった場合ですね、うちのもの特許が侵害されましたと、あるいはその会社の営業マンとか、あるいはその会社の、代理店とか、あと情報を集めたかもしれません。そういう情報を入手してからですね、早速ですね、それ調査したいと思います。会社とクライアントと打ち合わせしたいと思います。どのように対応した方がよろしいのか、どのような情報を集めた方がよろしいのか、それは課題になります。さっき申したように、例えば会社の営業マン、あるいはですね、代理店から情報入手するのも可能です。もしも新会社のサンプルを購入できればですね、これを買っていって、実務では例えば日本の会社でしたら、日本の会社がサンプルを購入して、社内でバラにして鑑定するわけですよ。侵害に当たるかならないか。これに対して大体会社の自分の判断ですから、やっぱり自分の有利な方向へですね、偏るんですね。そういうような場合には、やっぱり中国の弁護士、弁理士、専門家にお願いするわけですよ。鑑定をお願いします。侵害に当たるか当たらないか。これは一つの情報の入手手段です。もう一つとしましては、例えばですね、侵害者が非常に悪意で侵害した場合、非常に証拠とかですね、非常に隠しているわけですね。このような場合には、調査会社を利用することも可能なんですよ。調査会社が調査した上で情報を入手して、できればサンプルをですね、買っていってて、入手してて、それをバラにして、ですね、分析して比較した上で侵害に当たるか当たらないか判断をするわけです。もしも非常に緊迫な場合にはですね、例えば裁判所に対しまして仮処分を申請するのも可能なんです。例えば裁判官の判断では非常に仮処分をする必要性あると、あるいは緊迫性あると、そういうことであれば裁判官から自らですね、侵害者のところに行ってですね、すべての証拠を抑えることになるわけです。その証拠を例えばパソコンとかサンプルとか契約とかすべて裁判所に持ち帰って分析するわけですよ。これも一つの情報入手手段になるわけです。それからこれ3番目ですね。2番目ですとですね、例えば製造方法とか使用方法とか特定が困難な場合にはですね、中国ではですね、例えば前回17年の模擬裁判の時にも中国の裁判官も申し上げたんですけれども、現場を検証する必要があるんです。例えばその使用方法どうなっているのか、製造方法どうなっているのか、原告としましてはなかなか証拠をですね入手することは難しい。非常に特定が困難な場合にはやっぱり裁判官はですね、現場へ行ってですね、検証することになるわけですよ。最近中国はですね、法改正をしていますけれども、やっぱり知的財産権の保護をですね、強化すると。今懲罰的な損害賠償制度を導入したんですけど、これ別の話ですけども、 巨匠責任の転換をですね、これをですね、強化したいと思います。例えば、裁判の場になりますとですね、原告は非常にもう力を尽くして証拠を集めようとしましても、なかなか困難な場合ですね、裁判官にもですね、申し入れてですね、裁判官の判断で、容疑者に対しまして証拠を出しなさいと、あるいは書類を出しなさいと、もしも容疑者が裁判官の命令に従った場合にはですね、これは原告の主張を認めることになるわけですよ。被告に対しましては不利になるわけです。ですから、このような場合には、やっぱり裁判所を利用することも可能なんです。それ一番になりますけれども、ただ情報を入手しました。新会費のサンプルを入手いたしました。バラにしてですね、比較をした上で、侵害に当たると。それから訴状を作成する場合には、中国では例えば東京のクレーム、東京請求の範囲をですね、同じか同じでないか、日本流で申し上げましたら、初めの構成要件をですね、満たしているか満たしていないか、詳細に記載する必要があるんです。これはあくまでも初め、実用侵害に限って申し上げますけれども、以上では中国ではちなみに申し上げますと、東京といったら中国では初め、実用侵害以上でも東京と言っているわけですよ。ですからですね、やっぱりですね、比較をした上で、ですね、初めの構成要件を満たしていると。例えば区別ある部分は、区別な部分はですね、重要か重要でないか、それについても説明する必要があるんです。例えば以上の場合は区別ある場合、あるいはですね、同じ部分がある場合、ですから同じ同一の部分と区別のある部分は美観に対してどれだけの影響を与えるか、これは判断の基準になるわけです。とにかくですね、提訴するときには、構成要件、初めの構成要件、東京請求の範囲、クレームについて、詳しく比較をした上で、訴状を作成した方がいいと思うんです。事実務では、大体ですね、3番から2番まで、1番まで、こういう順序になっているわけです。以上です。
はい、ありがとうございました。大変面白いお話でした。念のために確認しておきたいんですが、今製造方法とか使用方法とか、そういうなかなかわからないものの場合は、裁判所に、頼んで現場の検証であるとか、そういうことができるというふうにおっしゃってましたが、それは訴訟の前でも可能なのですか？
訴訟の前でも可能です。私は担当した事件は、訴訟の前に裁判官に申し入れて、ですね、それやったことあります。裁判官は非常に協力しております。それは裁判の途中にいてもですね、例えば事件があったんですよ。要するに、例えばさっき韓国の方もおっしゃったんですけども、被告さんは、いや、うちの会社の営業機密に関わると、その方法をですね、裁判の場で公開できませんと、このような場合には裁判官にお願いしまして、裁判官の判断で、両方の代理人の弁護士とか弁理士だけにですね、情報を公開させますと、もちろん弁護士とか弁理士はですね、守秘義務はありますけれども、このような場合には、やっぱり十分にですね、被告さんのそれは方法ですね、調べた上で裁判官が判断することになります。
ありがとうございます。もう少し質問してよろしいでしょうか。
はい、どうぞ。
例えば訴訟の前にその現場の検証をやってもらうという場合に、その原告の方ではどのくらい侵害しているらしいという何か、裁判所に対して、証明というか証拠というか、そういうそのことをする必要があるんでしょうか。それを無制限に認めると全く根拠もないのに、検証してくれという話をやって相手の技術を見てしまうというようなことは起こらないんでしょうか。
はい。実は実務ではこれが非常に難しいことですけれども、やっぱり裁判官に申し上げて非常にその必要性あると。なぜ必要性あるのか、例えばですね、もしもその侵害行為を抑えることができなかったならば、原告は非常に莫大な損害を受ける恐れがあるということと、それから技術分野、あるいはその製品についてはですね、製造する会社が少ないから、例えば市場調査した上で販売する会社はですね、例えば1社2社もしかないと、このような場合には、例えば原告はもちろん販売しますけれども、容疑者はですね、被告者も販売するわけですよ。例えば製品はですね、原告の判断で非常に侵害する改善性は高い、そういうことであれば、裁判官にですね、訴えることができれば、裁判官は協力してくれる場合が可能性が高いと思います。
どうもありがとうございました。それでは、now we next ask Australia. And I will repeat the same question. Could you explain to what extent the plaintiff has to specify the features of the accused product or method at the commencement of the lawsuit in Australia? And what measures are taken if it is difficult for the plaintiff to specify the features? Maybe you may not understand my questions because, in Japan, the plaintiff has to specify the product at a very early stage or at the commencement of the lawsuit. But I think that it might not be the case for the Australia. So how the litigation proceeds as to how to specify the alleged product?
Thank you. Well, I think in that respect it is not so different to Japan. Obviously we have discovery in Australia, and that was a distinction, but in terms of commencing patent infringement proceedings, the documents that the patentee needs to file have to set out the particulars of the alleged infringement. That's either in the body of the document or a separate document. And our federal court rules require that the particulars of infringement specify which claims are said to be infringed, and the wording in the rules is that the patentee has to give at least one instance of each type of infringement alleged. And that has been taken to mean the nature and the quality of the act or acts said to be the infringing acts. And so that means that it could quite possibly be the case that a single claim might be infringed by a number of different acts, but in that case you have to specify that as well. And it's quite important that this is done with some particularity because the lawyers who are filing the lawsuit on behalf of the patentee also have to give a certificate to say that there is a proper basis for filing the lawsuit. So we need to make sure that we comply with the rules specifying which claims are infringed and the acts which we say are the infringing acts. If the plaintiff is having difficulty in doing that, we do have a procedure under our federal court rules, in addition to the discovery process that is available once a proceeding is commenced. We can apply to the court to seek discovery from a prospective defendant. So before proceedings are commenced, if a patentee thinks they might have a basis to file an infringement proceeding, but they don't yet know whether they have enough information in order to be able to commence the proceeding and indeed fulfil the requirements of the federal court rules, then they can apply for what's referred to as preliminary discovery. And so in that case, what the patentee needs to do is they need to persuade the court that they have a reasonable basis to believe that they have a claim against the prospective defendant, and that they've made inquiries but they still don't have sufficient information to decide whether or not they can actually commence a proceeding. And if they believe that the prospective defendant has documents which may assist the patentee to know whether they have sufficient information to commence the proceeding, then the court may order that the prospective defendant give production of documents. And those documents may then assist the patentee to decide whether they have sufficient information and whether they can sufficiently describe the features that would comply with our federal court rules.
Thank you. Well, let me ask one more question. How often, you referred to preliminary discovery, and how often are they used in reality?
That's an interesting question. I think it is certainly not an uncommon procedure. In fact, there was just a judgment given a few days ago in relation to a preliminary discovery application. One of the issues with a preliminary discovery application is that the patentee has to say to the court, I don't have enough information to know whether I should commence a patent infringement proceeding. So it is a strategy that involves some degree of risk, because if that application for preliminary discovery is unsuccessful, then the patentee has told the court that they don't have enough information. And because we have the requirement to give a certificate when we commence proceedings, you would not be in a position to sign that certificate.
Thank you, very interesting. Well, let me ask the similar questions to India. I understand that under the general law of evidence, the onus or burden of establishing infringement is on the plaintiff. And I think that is the same in every country. But, well, first, I have the same question for India as other countries. Accused product or method should be specified fully at some stage of the infringement lawsuit. And to what extent the plaintiff must describe the alleged infringing product or process at some stage? Could you explain?
Yeah. Let me explain in two scenarios. Scenario one relates to products. Scenario two relates to processes. Because the laws operate differently. In the case of a product, assuming it's a mechanical product, which can be looked at, it can be inspected, then there are two cases. It may be available on the market, or through investigation, or not available. If it is available, there is an obligation to describe it fully.
I see.
If it is not available on the market, then also if it has been advertised, let's say on a website, then that advertisement may amount to an offer for sale, which is also a restricted act amounting to infringement, so that even though the product is not available, you can go to court and get an injunction or get the defendant to come and answer whether the product has been made, not made, introduced in the market or not. As regards the first case, let us assume that it is not just a pure mechanical product, but it has a telecom element, like it is a handset which has got standard essential patents. Then it may be, you may be able to test it to prove infringement, the defendant's appliance, or it may be difficult to simulate the environment of a base station and of the elements of the claim. If that becomes difficult, you may rely upon essentiality reports to show that this is a standard and that your claims map to the standard. The defendant is following the standard, therefore he infringes. So you, by inference, inferential logic, you are able to stop the defendant. This is as regards the mechanical objects. What about chemical? If it is chemical or pharmaceutical, then also, if it is available, you may have to examine it in a lab, or if it's not available, then the same Section 48 offer for sale issue will arise, whether the person has advertised for sale, and that might amount to an offer. Now, there is no pre-suit discovery in India, which means discovery is only after you file a lawsuit. That's very important. But you do have a concept called a qua timit action. A qua timit action, it's spelt as Q-U-I-A. In a qua timit action, if you can show that you have a reasonable apprehension that the defendant is manufacturing or selling or offering for sale a product, you can go to the court and you have a cause of action. Now let me come to the second case of a process. If it's a process, we have a unique provision, Section 104 capital A, which reverses the burden of proof, provided that the process is for obtaining a product, 1. 2, the plaintiff proves that his product and the defendant's product are identical, and 3, the plaintiff has tried his best to obtain details of the process but has not been successful, and here he may have investigated, he may have looked at the packaging, the product literature, the website of the defendant, he may have looked at the patent application filed by the defendant, he may look at various sources, but despite that he may not be successful, in which case the defendant must prove what his process is. That's where the burden gets reversed. You can have a confidentiality club. You cannot force the defendant to disclose the commercial details or secrets, except those that are relevant for determining patent infringement. And a confidentiality club may be set up to preserve the defendant's confidentiality. In the present case today, 104A didn't apply, although this was a method claim, for the reason that there was no doubt about what the defendant was doing. If there was doubt, you could seek that knowledge by reversing the burden. But in this case, there was no doubt, it was a matter of claim construction. And the logic you had asked, the logic of this reversal stems from Article 34 of the TRIPS agreement, which has a similar mandate. It allows countries to reverse burden of proof in situations such as this. Would you like to add something?
There are two cases which I can specifically give as an example. In one case, there was a pharmaceutical case involving a polymorph. So the court said that the plaintiff ought to have given the X-ray diffraction data for that. The tablet was available in the market. So the court said in these kind of cases, the plaintiff has to do the testing. In another case, it was another pharmaceutical product. The court said give the liquid chromatographic test, HPLC test. And recently in the antenna test, which was cited during the arguments, the case involved an antenna for 2G, 3G telecommunication equipment. And the question was how to ascertain infringement. It could be ascertained only by giving the beam pattern of the antenna. The beam pattern, the beams which are, emitted from the antenna. So the plaintiff tried very hard to get the antenna's beam pattern, but he could not get it. So they used a presentation made by the defendant in a third-party service provider's premises to file the suit. During the course of hearing, the court directed the defendant. The plaintiff said they're not disclosing it. The defendant chose not to disclose. So the court drew an adverse inference against the defendant. The court said this is something purely known only to the defendant. They are not giving the antenna. The antenna is a very big equipment, so inspection could not be ordered. So the court drew an adverse inference. So in some cases, I recall that in process patents, the court has appointed commissioners to visit the defendant's premises to collect the raw material details which are being used, as also the byproducts that are being generated from their manufacturing registers in the processing plant, so that it can be ascertained as to what is the process that the defendant is following. So even this is a very usual order which is passed by the courts in India.
Thank you very much. Yeah.
ちょっと重要な一点を補足したいと思います。よろしいですか。中国の訴訟の実務ではですね、証拠保全は非常に重要な手続きになっているんです。例えば先申し上げました社内の鑑定、中国の専門家の鑑定が終わりますとですね、審判に当たる。そういうことであれば、公表医薬番の人と相談するわけですよ。公表医薬官の交渉人は現場に来てもらって、店に来てもらって、証拠保全をするわけですよ。そのサンプルを買っていて、後で交渉人の人とは、大体2人が同行してくれます。私と誰が誰と一緒にどこに何を見たのか、何を買ったのかをですね、買いましたサンプルをですね、交渉人が封印します。それでもしも証拠保全をしなければですね、自分で買ったサンプルを裁判所に持っていきますと、その場で相手が反論していきましたら、裁判官は判断が難しくなるわけですよ。もし交渉人が封印して証拠保全が終わっていれば、その証拠は裁判官に認められます。ですからこの点についても十分に注意していただきたいと思います。もしも皆さんがうちの事務所にお越しになっていれば、うちの侵害品の展示指数の中にはまた裁判になっていない証拠保全が終わっている違法物件がたくさんあるんです。ぜひ注意していただきたいと思います。
Thank you. Overall, I had a feeling that Australia has a very flexible approach to how to specify the alleged infringing product and how to gather information. And India also has a special program for which the defendant, plaintiff can easily collect evidence. And overall, I have a feeling that in your countries, the court takes a very active role in forcing the defendant to disclose their product or process. That's my personal feeling. Do you agree? Yes. Yeah. Thank you.
Yes.
I think that we have asked all the questions we prepared, and I wish I could continue the discussion, but it is time to wrap up. So I would like to thank you all of the judges and attorneys for your precious participation in the panel discussion. And I'm sure that everyone in the audience has enjoyed the diverse perspectives and have learned something new. I would like to thank everyone in the panel and in the audience for your participation. And let us give a round of applause for the panelists.
.パネリストの皆様、そしてモデレーターのお二方、本当にありがとうございました。